Welcome back. Episode 3 on What's on Tap. Notice the panel's a little different? I'll tell you what happened. We looked at those surveys. Scott Best, you're out. Andy Condiles has joined us today. Andy is from our Philadelphia office as well. He's an expert in both Pennsylvania and New Jersey law. So, Andy, welcome to the panel.
Thank you. Also
back with us, Cam Deane. He has made 2 cuts now. Very impressive. We don't know how much longer he'll last, but as we talked about, please keep those surveys. Keep filling them out when you sign on. We do look at that information. It is important to us because we want to make sure that the content we give you guys is what you want. We want to make sure we're giving you the things that you're asking for. Also, the questions. Guys, you've sent us some great questions. Keep them coming. I think at the last episode, if I'm not mistaken, Cam, what did we get? 50, 60 questions, give or take?
Mm-hmm. Yeah.
It was something. So we do appreciate those questions coming in, and it really is something that gives us the ability to share some feedback with you. Also, the PowerPoint will be available to you at the end of the session. In addition, the recording will be there as well. So with that, I'm going to kick it off this time. Last time, Scott introduced a great beer, Cam as well. Oh, and by the way, those beers that we introduced, we've been getting some great feedback from those. I mean, some folks, I'll speak for myself, I don't know about you, Cam. A few people reached out to me and said, you know what, those beers you guys recommended, we tried them, and we love it. I mean, what do you see on your end?
No, I'm getting the same type of feedback, Mike. Along with responding to questions, it has been giving advice in terms of what types of beer I'm seeking out nowadays. So the feedback from our audience has been great on that front. That's
great. So we appreciate it, guys. Please keep it up. So now here's one that is a personal favorite of mine. This Little Piggy from Idaho. Funny name, yes. It's from a brewery called the Sterling Pig. Locations in Media and Westchester. Let me tell you guys, it's a great bar, the one in Media. Get there often, enjoy it there. So we highly recommend This Little Piggy from Idaho. So with that in mind, what is our next topic? What are we talking about today? The topic is one that has kind of been brought up a lot recently, and we thought it'd be a good time to kind of get some information out on it. So it's cross-collateralization, set-offs, and the impact of bankruptcy. So this topic really has a lot of things going on with it. So Andy, why don't you kick us off and kind of talk to us first about the concept of set-off. What's that all about?
First, let's define what a set-off is. A set-off is when funds held by an institution on behalf of an individual are used to cancel out the past due portion of a debt that the individual holds. Let's use an example. Say a person has $10,000 in their savings account, $5,000 personal loan, $1,000 of which is past due. What the institution can do is take $1,000 from their savings account and set off or cancel the $1,000 of past due debt. So needless to say, this is a pretty effective tool. What makes it particularly useful is you don't need to get any sort of consent from the debtor, and you don't have to give them any sort of notice before you do so. Give them this notice afterwards is usually a pretty good idea so they know what's going on, but there's no actual affirmative consent that the debtor has to give.
But anyway, where does the authority for that come from, though? So it's you're saying I've got these 2 accounts and I've got an account and I'm going to set off against that $5,000. Where does the authority come from to do it?
Authority comes from case law, but again, it's not something that you have to give the defendant notice of.
So there's a case law element to it.
Right.
I think it also relates to cross-collateralization in certain ways related to in those agreements. Is that fair to say?
Yes, yeah, it is something that you can put in the agreement, but again, there's nothing where they have to affirmatively consent to giving you that authority.
Okay. I didn't mean to interrupt. Good.
So yeah, again, pretty good tool. However, there are some restrictions in terms of the funds that can be used. So typically, the funds that can be used to draw money from are funds where the bank actually holds, or the institution holds the funds, and funds that cannot be used are funds where the bank is the custodian of the funds. So, for example, savings accounts, checking accounts can absolutely be used, and accounts such as IRAs, 401ks, where the institution is more of the beneficiary, or is holding it as a custodian, are accounts that cannot be used.
So what do you mean by a custodian? Kind of define that a little bit for us.
Sure. Custodian is where the money is not actually held in that institution. So, for example, 401k, the funds are usually held in some sort of equity fund, and the bank is more of a conduit to remit the funds as opposed to actually having the money in their vault, so to speak.
Okay.
And the types of debts that can be used to be set off are pretty broad. The only exception that I would call your attention to are consumer credit cards. Consumer credit cards are not, not a type of debt that can be set off.
Now, why is that?
The CFPB set forth the rule prohibiting the use of set-off, the set-off tool to cancel out debts.
Now, is that infamous Reg Z that people talk about?
It is the infamous Reg Z
Gotcha.
rearing its head again and limiting your ability to set up those types of debts. But aside from that, it's pretty broad in terms of the types of debts that can be set off. It includes loans, guarantees, even things like overdraft fees. So again, it's a pretty broad tool, but you have to be really careful when it comes to credit cards. And the three requirements or elements of a set-off, there are a valid debtor-creditor relationship, mutuality of the parties, and the debt has to be past due. So when it comes to a valid debtor-creditor relationship, all it means is institution A lent debtor A money, and now institution A wants to collect money from debtor A.
Gotcha. So a relationship between the parties, usually the institution and their customer. Is that fair to say?
That would absolutely be the
Okay.
case, because again, they've got a loan with this institution and they have some sort of checking account, savings account, what have you, with the institution.
Gotcha. Now, you said there's two other requirements. Tell us about those.
Two other requirements. Also, the party that you're trying to take money from has to be the same as the debt that you're trying to collect against. And typically, it sounds pretty simple. However, it can get a little more complicated when there's a joint account, or where maybe the debt is held by a sole proprietorship, and you're trying to take funds from someone's individual account. So those are situations where you want to tread more carefully. But again, where it's really clean, individual A is the only person on the account, and they're the only debtor, that element is satisfied. And the third element.
But for those joint accounts you're talking about, those sole proprietorships, would it be fair to say those are the opportunities to come to reach out and say, hey, get some advice first? Because is it fair to say you want to be careful with those?
You absolutely want to be careful, because if you mess that up, it can become a cause of action and really can cause some problems for the bank, not in addition to ruining potentially the relationship you have with your client.
Makes sense.
And the last element is that the debt has to be past due, or due and owing is often the term. What that means is you can only set off the portion of the debt that is actually in past due. So in the example I used at the beginning, where there's the $5,000 debt and $1,000 of debt that was past due, the only portion of the debt that can be set off is that $1,000 that's actually past due. The balance of that loan cannot be set off. However, if there is some sort of acceleration clause and the entire debt becomes past due, then that entire debt can be set off.
Okay. That makes a lot of sense. So I guess does that tie in a little bit to the cross-collateralization topic?
Yeah, absolutely. It's an effective tool, but cross-collateralization is also another tool that can be used.
Okay, and within that cross-collateralization world, so what that basically is you have a security interest in one account that pretty much goes across many different types of accounts, right? So it's basically within the contract, you put language in there that says, you know what, we are basically going to bundle, for lack of better terms, the progressive bundle, all these loans together in some form, and yet that security interest is going to carry over. So what you see in these cross-collateralization clauses is the ability that if a default may happen in one account, you can then go ahead and collect on that account through one of the other loans or collateral secured by that. What you need to be very careful with when putting together these cross-collateralization clauses is the wording matters, right? The wording is the most important thing. Make sure that you're tying it down properly, because it is a great tool to have, but if you don't use it properly or don't put it together properly in your loans, you have an issue. And I want to talk a little bit about what Andy mentioned in reference to credit cards. Credit cards, since the infamous Reg Z, has kind of changed the game a little bit. However, what Andy's absolutely correct. You cannot set off a credit card. However, you can create a security interest that can basically, for lack of a better term, be cross-collateralized. And by that I mean, keep in mind, folks, before Reg Z, it was not an issue. Since Reg Z, you can still do it, but you must be very, very careful that you have consensual acknowledgement of the security interest being created. Highly recommend that it's bolded, it's out there for the customers to see. So it's one of those things that you're actually not setting off. It's one of these legal terms. I'm not setting off it. I'm foreclosing on it. So there is a difference. So it's one of those things to keep in mind that you do have that option, you do have that ability. So those are the types of things when I look to cross-collateralization, set off, great tools for any institution to have. Now I want to turn it over to you, Cam. So how does all this play into the world of bankruptcy?
Well, thank you, Mike. And of course, any lending institution should be aware that any of your customers or borrowers could, at any time, file a bankruptcy, and there's a lot of information to know about how that process works, and especially how it applies to your accounts you want to set off or how you will enforce your cross-collateralization agreements. So the first and most important thing to understand about any bankruptcy filing is the automatic stay and what exactly that means. So if you have a borrower who files a bankruptcy, you're going to receive a notice of the automatic stay and a notice of the bankruptcy filing in general. That means you need to stop every type of collection activity you're currently undertaking to recover money from that borrower. Now, the first step is to stop sending out billing notices or stop communicating with that lender or borrower directly in any way. And instead, you need to direct all of your correspondence either to their attorney or to the bankruptcy court. But I would strongly recommend reaching out to an attorney to seek advice for the specific account you're talking about.
Now, Cam, what's the consequence of violating that stay? What's the issue there?
Sure. So if you were to continue to self-help or take collection actions against the borrower directly without going through their counsel, their attorney, or the bankruptcy court, then you are exposing yourself to sanctions for violating the automatic stay. Now, the nature of those sanctions can depend on the jurisdiction you're in, but generally what would happen is the debtor would file a motion for sanctions in bankruptcy court, and using the Eastern District of Pennsylvania as an example, if they can prove they suffered actual damages, for example, if you were to set off funds in their account, they can turn around and file a motion for sanctions for your stay violation in bankruptcy court, not only to recover the money that you tried to recover from them, but also to recover separate damages directly from the institution itself.
And this applies to billing statements as well. Is that fair to say?
That is correct. So if you are sending out billing statements on a monthly basis to a borrower in the mail, those have to stop as soon as you receive notice of that bankruptcy filing, because that billing notice might just be informational to you, but it is an attempt to collect a debt from that borrower. And that is something that you can no longer undertake once you've received that notice of bankruptcy stay. Now, with consumer bankruptcy, there's typically two chapters that an individual will file. One is a Chapter 7 bankruptcy, the other is a Chapter 13 bankruptcy. Now, in a Chapter 7 bankruptcy, it generally looks like a liquidation of assets, and then those funds will create an estate, similar to when a person passes away. That estate will then be distributed or paid out to all the creditors who file a timely claim. Now, generally speaking, Chapter 7 cases are filed as no asset cases, and so that means there is no estate that gets created, there is no liquidation of assets, and there is no distribution to creditors, because usually the people that file that type of case simply don't have any assets that are worth liquidating in the eyes of the bankruptcy court.
Now, what do you mean by an asset? Is an asset, as a common person's thinking about it, so an asset, if I got a couple bucks in my bank account, maybe I have some equity in my home, is that considered an asset, not an asset? How does that play out?
Both are considered assets. So the way that a bankruptcy court looks at them is really it's any type of property, whether it's cash, money deposited into a bank account, home equity, automobiles, virtually anything that a person has the right to sell or transfer to another person is considered an asset in the eyes of bankruptcy court. But similar to the exemptions we discussed during our garnishment episode, there are exemptions to various types of property that a person is entitled to keep through the bankruptcy process. And so oftentimes, unless a person has tens of thousands of dollars in equity in their house, that house is going to be protected. Unless they have tens of thousands of dollars of money in the bank account, that bank account's going to be protected. And that is something that a bankruptcy attorney could explain to you more fully, is your understanding why you're not getting any recovery from this bankruptcy proceeding.
And that bankruptcy attorney is you.
Yes, you can reach out to me or Gary Masterson of our Cleveland, Ohio office. Both of us can be a great resource for you, the institution, to know how to respond to these types of questions once you receive the notice of bankruptcy filing. Now, going back to Chapter 7 cases, and I wanted to discuss the concept of reaffirmation agreements and how they apply in those cases, especially as it relates to cross-collateralization that you discussed before. So a reaffirmation agreement is essentially an agreement between you and the debtor that treats that loan as if the bankruptcy had never affected it. And what I mean by that is, a car loan as an example, you can send this document to the debtor's attorney. It will outline the terms of the auto loan as you're offering it to the debtor. And if the debtor signs it and files it with the bankruptcy court, they have reaffirmed their obligation to repay that auto loan. And that means that the discharge they receive in that Chapter 7 bankruptcy does not apply. So that means you continue to send billing notices. If after the bankruptcy the borrower defaults on that loan, you can repossess the vehicle, you can dispose of the vehicle, and if a deficiency balance is owed, you can try to collect that deficiency balance from the debtor despite the fact that they filed a bankruptcy. Now, as cross-collateralization comes into play, that is something I've seen lenders try to include balances on, say, a personal loan or a credit card that has been cross-collateralized with an auto loan to a borrower. It is always an option for you to offer a reaffirmation agreement that includes those balances. The issue, though, is that a reaffirmation agreement is subject to bankruptcy court approval. So if you are trying to say, debtor, you owe me $10,000 on the auto loan and another $10,000 on a credit card, and I want you to agree to pay back all $20,000 in order to keep your vehicle that's only worth $10,000, you may have a bankruptcy judge who says this is not practical, and this creates an issue with that debtor receiving the fresh start they're seeking in the Chapter 7 bankruptcy.
What type of success do you see with these reaffirmation agreements when you're dealing with cross-collateralization clauses?
So generally, you're going to have issues if you try to include the entire unsecured debt balance in there, even though it is a legitimate secured debt based on the terms of your contract and cross-collateralization clause. The issue is you're going to have debtors or their attorneys say, no, we're simply not agreeing to that, or you're going to have bankruptcy judges say, this is not a feasible option for this debtor in this case. So usually I don't see a ton of success in offering it, but it's not a terrible starting point to at least start a negotiation, because that's really all you're doing with these reaffirmation agreements is negotiating a new loan, more or less, is how you can look at it.
Okay.
Now, in Chapter 13 cases, you have a little bit more authority to proceed with your cross-collateralization agreement and enforcing it. There, you're actually going to be filing what's called a proof of claim, which is a document saying, I'm a lender in this case, here's how much money this borrower owes me. There will be multiple types of claims you can file, being a secured claim or an unsecured claim. Now, in order to enforce your cross-collateralization clauses, you're going to want to file all of your claims, whether it's a credit card, a personal loan, an auto loan, or a home mortgage loan. You're going to want to file those as secured claims and reference the cross-collateralization provision of your contract. That will give your claim a higher priority over other unsecured debts like a traditional credit card would be in a Chapter 13 case. Now, what that means practically for you is a Chapter 13 bankruptcy involves a debtor usually repaying debts over a 3 to 5 year period of time. The debts that get paid back are based on the assets that debtor owns as well as their monthly income, and they are paid out in an order of priority with certain debts like past due taxes owed to the IRS or domestic support obligations being top of the list, and then credit cards or other general unsecured debts being at the bottom of the list. Secured debts fit somewhere in the middle of that, and so if you can enforce all of your claims to secured debts, that will ensure you maximize your recovery in a Chapter 13 bankruptcy case.
That's good to know. So I think this is probably a good break to take some questions. I see we had a bunch of questions coming in, so let's see what we have. Thank you. So let's see the first one. Can I include a balance owed on a personal loan on top of the balance owed for a car loan, a home mortgage, when offering a reaffirmation agreement? Well, Cam, that is definitely a question for you.
Yeah, and so we touched on that briefly. This is an issue where you can always start at that point, and what I mean by that is prepare your reaffirmation agreement with an overall balance that includes all these loans. But a reaffirmation agreement allows you to renegotiate the interest rate or the balance, or really essentially make any offer that you want to the debtor to get them to sign a new obligation that gives you the ability to enforce that debt against them at a later date, despite the bankruptcy filing. So with that being said, if I were the attorney for the debtor and I see this reaffirmation agreement comes in and they want to have you, the creditor, wants me to have my client agree to pay you $30,000 on a vehicle loan that's got a vehicle only worth $10,000, I'm going to advise my client not to sign that agreement. I would need a more reasonable offer in order to instruct them to proceed. Now, once you get past the issue of what the debtor's attorney is willing to do and advise their client to do, you then have the issue of what the bankruptcy judge is willing to accept. And a bankruptcy judge is going to take into consideration factors such as the income of the debtor, their other expenses aside from this particular debt, and they're going to decide if this is a feasible option for that debtor to engage in or not. So there's a lot of considerations that go into what you should include in that reaffirmation agreement when you're making that offer to the debtor's attorney. But the short answer is you can start there.
Great. That was a heck of a good question. Let's move to the next one. Annie, this looks like it's going to be one right for you.
Okay.
What if the amount of money in the debtor's deposit account is less than the amount of the matured loan? What happens in that circumstance?
It doesn't really present a problem because, let's say, use the example before, someone has $900 in their deposit account and $1,000 of past due debt. You can simply set off the amount of money that they have in their account, in this case $900, and then pursue the overage through the traditional collection methods. So not a problem. It's a way to kind of mitigate the outstanding debt before you pursue other collection methods.
Great. That is a great tool, isn't it, those set-offs?
Absolutely.
So let's see, a final question here. If a member has an installment loan with us that is in default and a current car loan, are we able to repossess the car under a cross-collateralization clause? I'll take that one. The answer is easy. That's a yes. So that's the beauty of these cross-collateralization clauses. It gives you the ability to get that collateral from multiple different sources as long as they're tied together and the loans are properly written. So let's kind of stop there. I know we've got some more questions, but I want to stop it here. And we're definitely going to get to those questions. Like in the past, guys, we 100% appreciate you guys sending us these questions. We're going to get you those answers, and you'll have them within 24 hours, so we appreciate it. Again, we would ask, please fill out the survey, grab that PowerPoint, get that recording. There's a lot of good information there. A lot of the information that's not even presented here, we have on those PowerPoints for you. Again, we're pushing the swag. One of the things, we get great feedback on the recommendations we've been giving, but we've also been hearing a lot of people reach out to us at a recent conference we were at. Had some people saying, hey, how can we get those What's on Tap polos? I can tell you, it's one of our favorites. We enjoy them. They are available. And like I said, if you happen to win and get that shirt, it's a keeper. And again, I would say at the end, Cam, Andy, and myself, we're all available for questions. You'll see our information at the end. Please feel free to ask us any questions. We'll make sure we get back to you. And then just looking into the future, what do we have coming up? So we have our next one coming up, which is number 4 in the series, and that'll be on May 16th. And on May 16th, it's going to be legal collection strategies to maximize your bottom line. What I ask is please make sure you recommend me in the surveys. I'd love to be here for another one. We lost some people along the way, but keep the vote for myself if you don't mind. Thank you for your time, and we really do appreciate it. Thank you.